Start. Para. On behalf of Ganga Bisan, the owner of the property, the answer to these contentions was that Order 2, Rule 2 only applies where the cause of action is one and the same, and that it cannot apply where the causes of action are different and the cause of action in civil suit number 36B of 1955 was separate and distinct from the cause of action in civil suit number 36B of 1960. Therefore, there is no scope for the application. It was pointed out that in civil suit number 36B of 1955, the claim was a claim upon the personal covenant to pay damages by way of penalty contained in clause 7 of the lease deed. It was a claim which had nothing to do with the claim for the possession of the property. The claim for the possession of the property, even assuming that it was under the same contract, was a claim on a separate cause of action, which is radically different from the cause of action for means profit or damages. Reliance was placed upon the provision, and it was urged that clauses A and B of that provision of the code shows that a claim for means profit for damages is found upon a different cause of action from the cause of action for recovery of immovable property. To the latter argument, the reply of Mr. Dev on behalf of the lessees was that Order 2, Rule 4 is merely an exception for which prescribes when several causes of action may be joined, and that an exception cause as an exception cannot be construed to alter the nature of the cause of action. It was also urged that Order 2, Rule 4 only applies where cause of action is one and the same, and it cannot apply where the cause of action is different. All these rules are to be found in Order 2, which is entitled Frame of Suit, and that is precisely also the subject of Order 2. Rule 1 merely prescribes a general rule that, as far as practicable, every suit shall be framed so as to afford ground for final decision upon the subjects in dispute and to prevent further litigation concerning them. This is more in the nature of a general policy statement than a mandatory provision. It lays down the principle which underlies the subsequent rules 2, 3, and 4. The words as far as practicable indicate that in each case the court will have to see whether it was practicable for the plaintiff so to frame his suit as to include a cause of action which he has omitted or intentionally relinquished. The words subject in dispute may also be noted. In the subsequent three rules, there are several different expressions used, such as cause of action, claim and relief, and obligation, and it seems to us that only in Order 2, Rule 1 was the generic expression subject in dispute deliberately used because Rule 1 was intended to lay down only a general statement as to the policy of the law, though some of the causes have, in considering these expression, equated it with cause of action. It seems to us that this generic expression subjects in dispute would equally comprise within it cause of action or relief or claim as the context may require. Stop.